Hi, dprjones. As you know, I'm the mass analyst. First of all, I'd like to tell you that I agree 100% with everything you said in your video entitled Thinking of Filing a False DMC Claim, and I urge everybody to watch your video. I agree with everything you said. I just want to say a few other things that you probably didn't have time to go into. First of all, anyone who sends in a DMCA to YouTube has to sign a statement, and I'll put the exact wording of the statement in the sidebar. Now, this wording isn't something that YouTube came up with. This is what the DMCA actually specifies has to be in the complaint. And in the statement, you have to sign in the complaint, you have to sign a statement that you are either the copyright owner or that you're acting on behalf of the copyright owner. And you also have to sign a statement that the information in the notification is accurate, and under the penalty of perjury, you're acting on behalf of the copyright owner. Now, the DMCA also includes another clause, Clause F, and it's entitled Misrepresentations. And it reads in part, any person who knowingly materially misrepresents under this section that material or activity is infringing shall be liable for any damages, including costs and attorney fees, incurred by the alleged infringer. What this means is that anybody who's had their video taken down because of these DMCAs does have the option of suing whoever's behind them. Now, whoever's behind them has been using Brett Keen's name, so whoever's doing the suing will end up suing this person in the name of John Doe, aka Brett Keen, and they'll use Brett Keen in parentheses because we really don't know who the John Doe is. Brett Keen denies up and down that he has anything to do with this. He says that I didn't send in the DMCA. Now, this wouldn't be the first instance where some anonymous poster has had their anonymity pierced. This wouldn't be the first type of case where someone's lost their anonymity due to a lawsuit. This happens from time to time in libel cases or in cases of people posting on stock message boards trying to manipulate the stock price by hyping or bashing a stock with false information. So it's certainly not unheard of for people to lose their anonymity through these sorts of cases. And the way it's done is this, at least in the United States. I file a lawsuit. Suppose I'm the victim of a libel. I file a lawsuit and I ask the court for a subpoena to send to the bulletin board, or in this case it would be YouTube, but if it were a libel suit on a bulletin board, I ask them for a subpoena forcing the bulletin board to cough up identifying information. Now, the court's not just going to grant my subpoena. They're not just going to grant my wish. I can't just waltz into court without any evidence whatsoever and say, gee, he said something nasty about me. I don't like him. Make the bulletin board cough up his identifying information. The court's not going to buy that. What the court will do is say, hey, do you have any reason, can you show us any reason to believe that you have a reasonable chance of succeeding in your case? You have to show me that you have some sort of viable case. Well, in this instance, it should be very easy to show a court that you have a viable case. You could do this with your eyes closed and your hands tied behind your back, and here's why. The person who's been filing these DMCAs has been doing this in Brett Keen's name. Brett Keen is the copyright owner of the material that has been copied. He's the only person who really has the authority to file the DMCAs. And he says, no, I'm not doing this. Which means that whoever's filing the DMCAs in Brett's name is misrepresenting himself. They're misrepresenting that they have the right to file the DMCAs, that they have the copyright in the works. So all you have to do is show the court the video that was removed, show the court a snapshot saying this video has been removed by Brett Keen, and show a copy of the video where Brett's saying, no, I didn't do this. And the court will know that the copyright owner didn't have it removed. Somebody falsely claiming that they own the copyright owner was behind, that they own the copyright was behind this. So of course they're going to grant a subpoena. And YouTube will then have to cough up any identifying information, probably just an IP. And then you can take that IP, and I'm not going to say it's going to work 100% of the time, but there's a reasonable chance that you take that IP, you can then subpoena the ISP that provider, the internet service provider that issued that IP, and get the name. Now, once that person has been identified, they may have to worry about lawsuits from several different people, because I'm guessing at least 4 or 5 different people have had videos removed because of this. Plus, I'd imagine that Brett Keane might have some cause of action because of this clown using the law in his name, imitating him, to make it look like he's the one sending out the DMCA, so that Brett Keane might be on this guy's case as well. I mean, if I were in Brett Keane, I'd be on this case even more than I would be on the false flagging situation. I mean, this would bother me even more than the fact that my channel's been falsely flagged. If I were Brett Keane, I'd sue his ass off. Unless, of course, Brett Keane is lying to us and he is really behind this, then I wonder whether Brett Keane would end up suing himself. But for the sake of argument, we're going to assume that Brett Keane is, at least in this case, he's telling us the truth, that he isn't behind it. So, just fleshing out a few details. Filing a false DMCA does indeed have its risks, and I'll be interested in hearing what happens in the future. I'll be interested in looking forward to any future videos you may have on this matter. There's one more point that I should mention. Whoever's been filing these DMCAs might be sitting back and laughing at himself and saying, "Ha ha, mass analysts, you say that several people might be filing lawsuits against me. Well, I don't have to worry about that, because they can't file lawsuits against me without giving up their anonymity. And people aren't going to want to give up their anonymity, so I don't have to worry about 4 or 5 people coming at me with their lawsuits." Well, maybe you're right, maybe you're not. Maybe people are willing to give up their anonymity. But even if they're not, don't be so smug and so confident in your ability to avoid a lawsuit because of this reason. Last year, the Second Circuit Court of Appeals issued a ruling which states that under certain limited circumstances, people can file lawsuits against others while maintaining their anonymity. Now, this particular case involved one of rape. The rape victim didn't want the person who attacked her to learn her name, and so the court did indeed grant her the right to remain anonymous while filing the lawsuit. The court filed the ruling that said that a plaintiff may only sue anonymously if his needs for anonymity outweighs both the prejudice to the opposing party and the public's interest in knowing the plaintiff's identity. In other words, it's going to be a very narrow set of circumstances where you can file a lawsuit against someone anonymously. It's not going to happen very often. But I would argue this. You shouldn't have to give up your anonymity in court in order to defend your right to free speech, to speak anonymously on the internet. I mean, what would be the value, or what good would the right to speak anonymously on the internet be if the only way you could defend it is to give up your anonymity in court? Well, this has been the Mass Analyst, under and in.